This is Colin O'Keefe here for LXBN TV. In a very big ruling, a federal judge in Texas halted President Obama's immigration reform executive action. Joining me now to explain the immediate impact and what's next is attorney Montserrat Miller. She's with Arnall Golden Gregory, and author on the firm's blog, Immigration Compliance and Background Screening. Montserrat, first off, let's look back a little bit. There were a lot of people who were, in a way, really counting on this executive action going forward. Maybe even potentially telling their employers that they were, illegal, but working on it. Does this potentially put employees and employers really in a tough state of limbo as they figure out this deferred action?
Absolutely, because the truth is that the administration was going to begin accepting applications for the revised DACA, Deferred Action for Childhood Arrivals, on last week, and Wednesday of last week. And because of the judge's order, they had to put that on hold. And so presumably you could have had employees who were working and thinking this is something that is going to benefit me, may have taken some steps to approach their employer about the fact that they could have a work authorization document, which in fact would be a valid work authorization document, and could have begun to take steps to put the employer on notice. And then all of a sudden, with the judge's order, which enjoins the administration from moving forward, and in fact, U.S. Citizenship and Immigration Services did halt and did not begin to accept applications for the expanded DACA, that could have had an effect on those employees and their employers with respect to what the employer would have then known about the employee that would have been different from the past when they thought they were work authorized, and maybe now moving forward, they could know that they're not work authorized.
Mm-hmm. It's an interesting point. I mean, as you mentioned, this really came in at almost the 11th hour, just as they were about to start handing out these authorizations. This ruling came down. So second, what's next here? I understand the Obama administration aims to reverse this ruling, but when it comes to that type of appeal, that reversal, what do their odds of success look like when it comes to pushing through this type of reform via executive action?
In the immediate, obviously, we know that the administration has filed a motion to ask that the judge's order be temporarily suspended and/or, if not, in the alternative, limited to Texas. We'll see what comes from that within the next, I think, maybe week as to whether the judge is going to agree to the suspension. But for now, I'm operating under the assumption that the injunction is going to remain, and that as it moves its way through the Fifth Circuit Court of Appeals, potentially to the Supreme Court, that this is going to drag out for some time. Applications that were going to begin to be accepted potentially in May for DAPA, the program for parents, are also on hold. So we're talking a population of maybe 4 to 5 million individuals who would have been affected by the expanded DACA and the new program, DAPA, are going to be impacted. But I want to get back to one point about employers with respect to work authorization and why this decision was significant. As an employer under the current immigration law, you can have either constructive knowledge, which is the totality of the circumstances that could lead one to believe that somebody is not authorized to work for you, or you could have actual knowledge. And where this could be implicated with the judge's ruling is if individuals went to their employer thinking this was a certainty, and then which would not have been unrealistic, because remember, there was a case in the District of Columbia, the federal court here in Washington, D.C., where the court said you do not have standing to bring this type of a suit challenging the constitutionality of the president's executive action. So it wouldn't have been unrealistic that they could have gone to their employers. And the reality is, putting aside the judges or the injunction for now, is that if you have an employee who has come to you hopeful that DACA would be expanded or that they would have this new program, they've come to you and have in fact told you, either I'm not the individual I said I was and I'm going to be bringing you an actual work permit that shows I'm work authorized for 3 years, which is what they would have received, or they may say, my circumstances are changing, they're going to change, I'm going to benefit under this new program, and I will bring you something. That is going to implicate that is going to lead the employer to know that that individual is not arguably could lead to a charge of constructive knowledge of continuing to employ someone knowing they're not authorized to work in the United States. So that's one factor. And the other issue that employers have to think about is, having said all of that, what is my corporate honesty policy? What's my company's policy when people come to me and potentially have made a misrepresentation about who they are or what their status in the United States is? Do we give people a second chance or not? So for employers, there were a couple of big issues raised by the judge's decision if employees, in fact, came to them hopeful that they would be eligible for these benefits.
It's going to be a very interesting thing to watch. As we mentioned, we can talk, day and night about the procedural elements to this and how this, is likely or could be heading to the Supreme Court. But, in the interim, there are real people out there, whether they be employees or their employers, who are just trying to make sure that they have a legal workplace. So, it'll be interesting to watch to see how this progresses. But it's important to remember that, behind the scenes or behind all of the litigation and that type of stuff, there are real people being impacted by this. So, we'll have to see just how it goes from here, and hopefully people manage in the interim. Once again, that was Montserrat Miller of Arnall Golden Gregory. For more of her insight on this particular topic, both what's happened and what's going forward, be sure to check out immigrationcomplianceinsights.com. Thank you for joining me today, Montserrat.
You're welcome.